We're beginning, ladies and gentlemen.
Again, the clerk has advised me that we have a quorum, and everybody is appearing in the room today. Nobody is virtual, no witnesses. No. So with that, committee members, I will call meeting number 109 to order of the House of Commons Standing Committee on Human Resources, Skills, Social Development, and the Status of Persons with Disabilities. Today's meeting is again taking place in a hybrid format, although all the committee members and witnesses are here in the room. I will go over a couple of comments. You have the option to speak in the official language of your choice. Interpretation is available using the headset in front of you. Click on the language you choose to participate in. I would ask you to just keep the earpiece away from the mic if you use it, because it can cause popping, which can hurt the interpreters. Please direct all your questions through I, the chair. Wait until I recognize you by name before you proceed. To get my attention, please raise your hand. If there's a breakdown in the interpretation service, please get my attention. We'll suspend while it is being corrected. Pursuant to the order of reference of Tuesday, February 27, 2024, the committee is continuing its study on Bill C-58, an act to amend the Canada Labour Code and the Canada Industrial Relations Board Regulations 212. For the first hour, we have witnesses, which will be the final group of witnesses for the review of C-58. Appearing today in the room is Jeanette Brazeau, Chairperson, Canada Industrial Relations Board. Madame, bienvenue. The Canadian Canola Growers Association, Dave Carey, Vice President, Government and Industry Relations. From the Canadian Telecommunications Association, Robert Giz, President and Chief Executive Officer. Eric Smith, Senior Vice President. Before we begin, I do have to acknowledge Mr. Giz's father, who was responsible for convincing me to enter politics, public life, back in 1982. 1982, Michelle. Welcome, Mr. Giz. We'll begin. Each one of you will have 5 minutes to give opening remarks or less, and we'll begin with Madame Brazeau, Chairperson, for 5 minutes. Madame.
Good morning, and thank you, Mr. Chair and committee members, for the invitation to appear before you this morning in your study of Bill C-58. I intend to speak about the board, its work, its responsibilities and structures, and explain the impact that Bill C-58 is likely to have on the board's operations. To this end, I provided a reference document entitled Information Document Relating to the Canada Industrial Relations Board, which I believe was distributed to the committee members. Le Conseil canadien des relations industrielles est un
The board is a quasi-judicial tribunal which deals with complaints or requests relating to work or employment. We offer mediation service for parties in a dispute, and we take decisions when necessary. The council is, the board has a president, vice president, 5 full-time and 3 half part-time. There are also 6 members that represent employers and workers in equal numbers. The panels for hearing of files are made up of 1 or 2 vice presidents and 2 members. The members may not sit alone to deal with files. The board is responsible for applying and interpreting various laws, including the law on the status of the artist, the law on the program for protecting workers, and, of course, the Canadian Labour Code. And we also have 5 distinct areas. Industrial relations, second, health and safety, third, basic work or labor codes, and part 4, the administrative and monetary regime.
Of the code, labor relations. In 2019, amendments were brought to the code that made the board responsible for all parts of the code. At that time, the code was also amended to allow the chairperson to appoint external adjudicators to help it or help us deal with certain types of cases. You will see from Chart 1 in the document that was distributed that since those changes came into force in 2019, the board's caseload has doubled. We went from about 500 cases a year to 1,000 cases a year. At the time these changes were made in 2019, there was funding identified for the board's new responsibilities. An amount of $3.4 million was approved for this purpose. However, it's important to note that the board does not have its own appropriations and does not have autonomy in the administration and management of all its affairs. The board's financial and human resources are allocated and managed by the Administrative Tribunal Support Service of Canada, the ATSSC. The ATSSC was created through legislative amendments in 2014. At that time, amendments were also made to remove the chairperson's role as a chief executive officer of the board and her authority to direct and manage the board's resources and budget and other administrative matters. Any funding that is identified or approved for the board is in fact allocated to the ATSSC, who exercises all the financial authorities and in turn determine how best to allocate the funding to the various tribunals it supports. As it relates to the approved funding in 2019, my observation is that that amount of $3.4 million has not consistently flowed through to the board. Our initial budget allocations over the last 5 years has not seen an equivalent increase. You will see that in Chart 4 in the document. This unpredictable allocation of funds makes it difficult to plan and address the board's caseload in a stable manner. This past fiscal year, for example, I was unable to assign any new files to external adjudicators for a period of 8 months, as there was insufficient funds allocated for this purpose. As a result, the board has accrued a significant backlog of cases and is experiencing increased delays in processing cases. You'll see that in Chart 2. The board's ability to respond effectively and in a timely manner to the disputes that come to us requires sufficiency of funds and the ability and flexibility to swiftly align or realign human and financial resources as the board sees fit to respond appropriately. All this to say that if Bill C-58 passes, it will be challenging for the board, with its existing structure and resources, to deal with complaints of replacement workers on an expedited basis, or for the board to address all maintenance of activities matters within 90 days without further impacting other types of cases that come to the board. I'm aware that the committee will have questions for me regarding the timeline for coming into force. In order to be prepared to meet the quick turnaround times that are required by this bill, there are 2 areas that will require attention, and I may be running out of time. The first will be the resources. I've asked for additional vice chairs to be appointed to the board and for additional resources to support the work. The second area is the need for new rules and regulations to be able to review and deal with these matters within 90 days. That will entail development of rules, consultations with our stakeholders, drafting and adopting of those new rules, and communication materials to ensure that people who come before the board understand the new process that we want to put in place to deal with these matters. So, as you can see, this will involve considerable work and several steps. Il me fera plaisir de répondre à vos questions.
I look forward to answering your questions.
Madame
Thank you very much, Ms. Bazot.
Harry, for 5 minutes or less, please.
Thank you for inviting Canadian Canola Growers Association to speak to you today during your study on Bill C-58. CCJ is a national association governed by a board of farmer directors that represents Canada's 43,000 canola farmers on issues and policies that impact on-farm profitability. I recognize this isn't the House Ag Committee, so I'll briefly provide an overview of our sector. Canada typically produces 20 million tons of canola annually and exports over 90% in 3 forms: seed, oil, or meal. These products get exported to 50 countries, and in 2023, our exports were worth $15.8 billion of canola alone. Canada is the world's largest producer and exporter of canola, and our industry supports 207,000 jobs and contributes $29.9 billion to the Canadian economy annually. Canola travels on average over 1,500 kilometers from the farm it is grown to an export position. There is no alternative for long-distance transportation of our products across the continent. We are completely reliant on Canada's 2 Class 1 railways to get the majority of our product to market. both now and to the future. Transportation of grain is one of several commercial elements that directly affects the prices offered to farmers. When issues arise in the supply chain, the price farmers receive for their grain can drop, even at a time when commodity prices may be high in the global marketplace. When rail service is disrupted, the worst case scenario is that space in grain elevators and process facilities becomes full, and grain companies stop buying grain and accepting deliveries from farmers. This can occur even when a farmer has an existing contract for delivery, potentially straining their ability to cash flow their operations. This is the reason that a major reason why Western Canadian farmers have such an interest in rail transportation. It directly affects individual farmer income, and beyond that, the ability of Canada's railways to move grain to export critically affects Canada's reputation as a reliable supplier of canola to the world. Today's grain supply chain is predicated on having the right grain in the right place at the right time. There are a lot of moving parts in this complex system, including trucks, inland collection points, railways, port terminal facilities, and marine vessels. All are required to move canola from the prairies, where it is grown, to international customers, where it is demanded. In such a complex system, in any given year, there will inevitably be incidents and events that negatively impact the fluidity and on-time execution of the supply chain. Weather, infrastructure damage, and other unforeseen events are often outside our influence or control. In Canada, we have enough risk to our supply chains from natural causes in any given year. Ones of our own making must be avoided. One element we do, broadly speaking, have control over is labor agreements and organized work environments. However, we have observed ongoing and concerning levels of instability between our Class 1 railways and their labor in recent years. Currently, our industry and Canada is bracing for the possibility of both Class 1 railways to have labor disruptions as early as next month. Even if a strike is avoided as the May deadline approaches, we are concerned there will be significant impacts on service for weeks or months to come. We saw a similar situation in March 2022 when one of our Class 1 railways approached the brink of labor action with one of their labor groups. Ultimately, a shutdown was avoided at the 11th hour, but there were still ramifications for supply chain fluidity with even the threat of labor action. In advance of labor deadlines, the railways began curtailing operations, sending a wave of logistical disruptions and delays back to the supply chain that took weeks to rectify. In November 2019, a Class 1 railway did have labor action that affected operations for a full week, with effects reverberating for months. Given the complexity of this system, it generally takes 6 to 7 days to recover for every 1 day of service disruption. As parliamentarians on this committee, I would ask you to consider these labor issues from the lens of our international customers and competitors. Over the last decade, our customers have seen strikes or threats of strikes, both of which disrupt the grain transportation system and affect Canada's ability to reliably supply our customers. This has led Canada to building a reputation as an unreliable supplier and unreliable trading partner. Labor to management issues naturally reside between those parties. It is a tenuous balancing act that is enshrined in law and evolving jurisprudence. It is not our intention as a farm organization to suggest a solution for these issues, but rather to highlight the second and third order effects when labor issues do arise. We want to produce more, grow more, and expand our exports that drive our economy's growth, and that labor is needed to get our products from the farm gate to export position. Looking forward, we clearly see further rising demand for our agricultural products, both domestically and internationally. At the end of the day, farmers will not be able to capitalize on the opportunities from increasing demand or trade agreements without a reliable rail and labor system that grain shippers and our global customers have confidence in. Bill C-58 would likely compound the significant issues that our sector is already facing through labor and supply chain uncertainties. Thank you, Mr. Chair.
Thank you. Excuse me, Mr. Carey. Now to Mr. Giz for 5 minutes or less.
Great. Thank you, Mr. Chair and members of the committee. We appreciate the opportunity to appear before you this morning to discuss Bill C-58. When Bill C-58 was introduced, we expressed our concern that the bill seeks to address a problem that does not exist and, for the reasons given to the committee by FEDCO last week, should not become law. While our position in this regard has not changed, if Parliament decides to pass the bill, it must first be amended to address an issue that should concern all Canadians, including members of this committee. Canadians rely on telecommunication services every day, and the security and reliability of networks have never been more important. To quote the Government of Canada, not only do telecommunication services support a wide range of economic and social activities, but they support other critical infrastructure sectors and government services and are crucial for emergency services and public safety. They are fundamental to the safety, prosperity, and well-being of Canadians. Il en va de même pour les services de radiodiffusion et de télévision.
The situation is the same for radio and television, which play an essential role to ensure public safety in Canada. These services are essential for the Canadian people. In case of any breakdown caused by natural catastrophes, acts of vandalism, or any other factors, consumers expect that their suppliers and their support teams will work tirelessly to reestablish service. That's exactly what is happening today.
Prohibition on the use of replacement workers in Bill C-58 would significantly weaken service providers' capacity to restore services and protect their networks from disruption during a strike or lockout. While some argue that requiring employers and the bargaining unit to establish a maintenance of activities agreement before a strike or lockout will mitigate the negative effects of the prohibition on replacement workers, this viewpoint is flawed. While Section 87.4 of the Code requires the parties to continue the supply of services to the extent necessary to prevent an immediate and serious danger to the safety or health of the public, the Canadian Industrial Relations Board has previously ruled that Section 87.4 does not apply to a potential interruption of telecommunication services during a strike or lockout. Nor are the limited exemptions to the prohibition on replacement workers under the proposed amendments to Section 94 of the Code sufficient to ensure the continuity of telecommunications and broadcasting services during a strike or lockout. Mr. Chair, I know you are intimately familiar with the devastation Hurricane Fiona caused in Prince Edward Island and its surrounding provinces. Imagine if telecom workers had been on strike when the storm hit our province. Under Bill C-58, the affected telecom providers could not use striking workers with the necessary experience and skill to protect and restore services or hire temporary replacement workers or contractors. This would have been unacceptable to Atlantic Canadians and should be unacceptable to Parliament. Experts predict 2024 could be one of the most active Atlantic hurricane seasons on record. Scientists say they are bracing for what could be another year of devastating wildfires across Canada, and cybersecurity threats, as we know, are on the rise. Compromising our telecommunications and broadcasting systems' reliability, resilience, and security in the context of a strike or lockout undermines the extensive and detailed steps taken by the government under its telecommunications reliability agenda. It also runs counter to Canadians' expectation that these critical services be there for them when they need them most. While we respect the right to strike, there must be a balance between workers' rights and the public good. We ask the committee to recommend to Parliament that Bill C-58 be amended to ensure that during a strike or lockout, service providers, their employees, and their bargaining units must continue providing services necessary to repair and restore telecommunications broadcasting services and to perform critical maintenance work. In fact, we know from a recent NANOS poll that 95% of Canadians say it is important that telecommunications services remain available without disruption, and that 8 in 10 Canadians think that telecommunications companies and their employees should be required to continue to provide the services needed to prevent and repair disruptions even when there is a strike or lockout. The amendment would be like one made by Parliament to ensure that labour disputes in the longshoring industry do not interrupt the movement of grain vessels. We've provided the committee with wording for the suggested amendment and a couple of other amendments that we ask the committee to please consider. We would be happy to discuss these during the remainder of the meeting. Thank you, Mr. Chair.
Merci, Monsieur Guis.
Thank you very much.
This morning, Mr. Seaback and Mr. Sheehan, back to the committee. We will begin with Mr. Seaback for 6 minutes.
Thank you very much, Mr. Chair. Ms. Brazeau, you talked about resources at CRB. I'm guessing that with the changes in this legislation, that would increase the workload. Would that be a fair assessment?
Thank you for the question. It is our assessment that the workload will increase, yes.
And do you have any estimate on how much the workload would increase? Would it be like how it went from 500 to 1,000 cases? Now it's going to go from 1,000 to 1,500, or do you have any estimate on that?
It's very difficult to give an estimate of the actual workload that will result from C-58. What I suspect, and maybe I can point to the chart for this. If you look at chart number 3, which considers the number of matters related to maintenance of activities that are currently dealt with by the board. You will see that every year we have about 25, 28 in the recent years, about between 25 and 30
Yep.
cases related to maintenance of activities. We deal with those, chart number 2, on average in 150 days, 130 days. And if you see, for example, in 23, 24, 14 of those cases were withdrawn. So what happens is, because of the current provision in the code related to maintenance of activities and the timelines that apply, they file with us, and then they ask us to hold the matter in abeyance because they want to focus on collective bargaining. And so we don't deal with those matters. Parties reach an agreement, and then they withdraw this application of maintenance of activities. So although we have 26 applications, we don't deal with half of them. Now, as I read the legislation, there will be a lot more pressure for us to deal with these
Because
applications.
you're going to deal with potential complaints that the employer is violating the statute and bringing in replacement workers.
Well, that's the other piece.
Yep.
Replacement workers, we don't necessarily have an estimate of what that will look like.
Right.
We know that there are about, between 25 and 30 disputes ongoing at any one time.
Yep.
And so, whether those units go on strike and whether replacement workers become an issue, it will result in
But
applications.
you're saying your funding right now isn't sufficient to deal with the volume of complaints. Is that correct?
That's correct.
And you anticipate that this bill will increase your workload, so therefore you'll be even less resourced to deal with potential issues. Would you agree with that statement as well?
It will be difficult for us to meet the timelines that are in the bill as proposed, yes.
And I took a quick look at the budget. I don't see any additional resources for your organization in the budget. Am I that's just been released? Am I correct on that?
I haven't seen or been informed of additional funding that were in this week's budget.
And there's certainly no additional funding that's being put forward to deal with the potential increase of cases from C-58. You haven't heard anything about that, have you?
Well, there's been ongoing discussions with the department
But
to
nothing's been
identify the amount of money that would be required.
But nothing's been announced or provided.
There is ongoing discussion on the amounts that could be potentially transferred to the ATSSC. for
Now,
this
what
purpose.
about the proposal by, we had unions here saying that the 90-day period is too long and it should be 45 days. Would that dramatically increase the resources that you would need to deal with issues?
Again, it will put pressure on the board, and whether we'll be able to meet that 45-day timeline, if that's what results from this committee, if that's what Parliament adopts, it will be challenging for the board to be able to meet that time frame with the existing resources. And not only that, it will,
Well, it sounds
everything
like
will be focused on that work, and the rest of the caseload will be delayed further.
It sounds like if you're having trouble making ends meet now with additional work without additional resources, you won't be able to do that. I think.
It will be challenging to meet the timelines.
Okay, thanks.
And we'll see an increase in processing times.
Right. Thanks very much. Mr. Giz, I just wanted to talk to you about, you obviously don't agree with this bill, but we had Mr. Strickland from the Canada Building Trades Union here earlier this week. He talked about an employer, LTS. They refused to meet with the union for bargaining. They went 2 years without a collective agreement. Then the union went on strike. And because they could bring in replacement workers, the strike went on for 6 years. You say this bill isn't necessary, but how can you justify hardworking families not having a collective agreement for 8 years and being on strike for 6 years because the employer just brought in replacement workers and said, too bad to these families?
Yeah, I'm not aware of the situation with the builders, but what I can say is this. The amendments that we're proposing to the bill would not involve replacement workers. They would involve workers that are already employed by the specific company that had the expertise to be able to continue to maintain those services.
All right. Well,
Okay,
I
thank
think
you.
I'll
Thank you,
stop
Dan,
there.
because
Thanks.
I'm going to hold everybody pretty close so that we can get through the 2 rounds. Thank you, Mr. Seaback. Mr. Sheehan for 6 minutes or less.
Thank you very much. And just following up a little bit on Mr. Seaback's questioning to Jeanette, we talked about the resources, and you keep referring to timelines. So could you just refer to, like, sort of a step-by-step, what are the timelines that would be needed? I know that we have stuff here, but there's a lot of people probably watching from coast to coast to coast. So if you could just kind of go through the steps which would be needed.
Just for clarification, you're referring to the timeline of dealing with these cases?
Yeah. In order to, how it is now, I suppose, and how C-58 would change those timelines.
Right.
Potentially.
So my reading of the bill and the requirements that are in that bill for the board to be dealing with these matters in 90 days means that a lot, if not all, of our resources will be focused on these types of applications, replacement workers and maintenance of activities, because they are that we are asked to deal with these on an expedited basis and within 90 days in the cases of maintenance of activities. We only have 5 full-time vice chairs that can deal with the board's caseload, as I mentioned, and three part-time. We have the ability to use external adjudicators, but the resources need to accompany that because we need to pay these external adjudicators. With the budget envelope that we have now, if all our resources go towards maintenance of activities, replacement workers, there'll be very little resources for other types of cases. So we'll see an increase processing time for other types of cases, unjust dismissal cases, health and safety matters that come to us. They'll just have to take a back seat if this bill mandates a 90-day turnaround time on maintenance of activities. And we see that right now it takes us on average 150 days. So we need to put more resources, change the way we deal with these matters in order to meet the 90-day timeline if we can.
So there's been suggestions at this committee that the length of time go from 90 to 45 days. So just a comment on that, just a brief comment for the record.
That would be a challenge, certainly, with even with additional resources. When dealing with maintenance of activities, we do have to hear from the union, from the employer, and consider what are the services that are being offered by the employer. That, we need to be fair to the parties. We need to ensure, principles of natural justice are respected. And so, to do that within 45 days on questions that are of that importance it will be challenging to do that in 45 days.
So coming into force as well has been talked about. And could you let us know, I mean, it's been suggested through the legislation about 18 months. It's been suggested that be shortened, perhaps lengthened, or stay the same. Comments on the coming into force. And in particular, the 18 months, not going longer, but shorter, from 18 months to,
Right.
say, something shorter.
So, as I mentioned in my remarks, there are 2 areas that we need to focus on to ensure that we can implement this legislation properly. One is the resources and the appointment of additional vice chairs. Both of those matters are not within the board's control. The appointment of additional vice chairs is a governor and council appointment. That's under the leadership of the Privy Council's office. It involves a process, cabinet ratification. It takes a long time to appoint additional vice chairs to the board. Obtaining resources and making sure we have those resources available for the board requires approval of Treasury Board and others, so that process is also or can be lengthy. On the internal board rules and regulations, we've already started thinking about what we could change in terms of our processing of these matters. But it's difficult to go out and consult with our stakeholders on the new rules before having the bill into place or before Parliament adopts it. Don't want to preempt or presume that Parliament will adopt the legislation, and so we'd want a bit of time to complete that work to make sure we have all those mechanisms in place to ensure appropriate implementation.
You're very well respected and I've heard from both the union side and the employer side, I think, from your history. What advice would you give to employers and unions to get ready for C-58, if you could?
The advice I would give in any dispute that comes before the board: how can we help you achieve agreement at the table? And because one thing I will say, and thank you for the comment about the board's reputation. I think the board's reputation is due to its credibility, its expertise, its ability to intervene in a timely fashion. And if we can't do that going forward, one thing they agree on, employers and unions, is that the board, the institutions that support collective bargaining are critical. They're critical to make the collective bargaining system work. And so if there is legislation that is likely to change that or affect that, that's concerning to me. And
Thank you, Ms.
I would ask
Brazeau.
that we be supported. Thank you.
Mr. Sheehan. Madame Chabot, pour 6 minutes.
Thank you very much, Chair. Thank you to our witnesses. First of all, Ms. Brazeau, thank you very much. I think that the board plays a major role in balancing the interests of employers and workers, and thank you for your presentation. I'm surprised to find to hear that you are responsible for the labor situation in Quebec. We have a separate entity as well. I think perhaps you would you should have additional resources, and I think that up until now, the union representatives have said that they have concerns with regard to this bill, and they are quite aware that the board would require additional resources, and I hope that once we have a robust bill that will protect the right to strike, and that the board will have the resources it needs, and there have been a number of witnesses who have told us that since there is a need for a mechanism for agreement and for preventing the use of replacement workers. Do you think that would something that would be desirable, or for us? Thank you very much for the question, and the board responds to complaints or requests made to us. And if there's a request with regard to replacement workers, we have fairly broad powers to and we can delegate authority and powers to representatives locally to go to the area to inquire. And there's already a certain investigation component, and how could we use these powers more broadly. This is something that we're looking at, and this is always, of course, a situation where we are responding to a complaint. If there was a power of inquiry from the ministry, already have that model with regard to labor standards, where the ministry undertakes an inquiry, and then often there's an appeal to the board. And this is an additional step that would be added to the process. And thank you. I've had an opportunity to, and we think that we want to have a law that will be effective and in the current context of a minority government, and it has taken a long time to work on this bill, and do you have any requests? We have, but the delay in the application of the law, 18 months. Well, we have asked for a period to ensure that we can study and coordinate with existing regulations. Do we have enough time? We'll see, but we have need as well for a lot of additional resources. And we don't want to have too negative effect on our existing workload. Thank you very much. And so current timelines for decisions, often it takes more than 90 days. And you know that there's often a cooling off period, and the 90 days is already a long time. And would you like to reduce time for dealing with these issues? And do you agree that it would be desirable to have shorter delays for responding to complaints? Well, it will be a challenge to decrease the time needed to deal with a file or a complaint, and to ensure we have the resources to deal with these files with regard to the members of the tribunal and our partners. And with 1,000 files per year to deal with, we only have 5 full-time vice presidents and 3 part-time vice chairs. So it's difficult to deal with so many files. So Madame Chabot, thank you very much, Chair.
Madame Chabot, merci.
Thank you, Madame Chabot. Mr. Boulris, you have 6 minutes. Thank you very much, Chair, and thank you to the witnesses for being with us today for this important bill, a historic bill. And just a comment to start, Mr. Giz, you said something during your testimony, which is fairly provocative, that C56 would provide a solution to a problem that doesn't exist. I don't really agree. And even in Quebec, every day we see people that are replacing workers, and this is not just in the port sector, but it's also in communications. And behind you, you have 4 people who are on strike for 6 months already. Videotron and Gatineau, who are seen their work taken by replacement workers. So it's a real problem. And after the end of the panel, I would ask you to go and discuss with them their situation. And these people who have been on strike now for almost 6 months. Ms. Brazeau, you said that it wasn't possible to act before Parliament has adopted the law, of course. But if And if the bill were adopted by all the parties, which is probable unless there's a change in attitudes currently, does the board or is the board trying to prepare for the adoption of the bill? Thank you for the question, Mr. Boulris. Indeed, we have started consultations with the Quebec Labor Administrative Tribunal with regard to their procedures and their with regard to replacement workers, for example, and we've spent time with them to understand their processes, and they have shared documentation and information with us, and we look at that. We look at the powers we already have under the we will have under the bill. And we're considering the procedure that will be necessary to change or add if the bill is adopted. And there are many people who have come to see me because it's always this issue of the long timelines, 90 days and more. Many organizations, representatives of workers have told us that often this takes too much time. And it has to be faster. So you've kind of opened the door to say it's possible. But what resources do you need in order to shorten these timelines? And I see that you, over the last number of years, you've been very much lacking in resources. And how much do you need to shorten these delays in order to create these new procedures or improve our procedures? We have to have a reasonable time to consult our partners and to train and educate our staff for the long term. Maybe we'll be able to do this within 6 months, but it's always a question of resources and additional people at the decision-making level who are capable of dealing with these files. We heard the proposal of 0 months. Is that possible? No, I don't think it's possible. With regard to the 90 days to provide a decision, there have been issues and requests to shorten that time. But if there is no decision within 90 days, there is also a provisional request from the union that if there is a decision which has not been rendered within the time set out in the law, if the board takes more time than what's set out in the law, I think that we can take provisional decisions. And what would be the basis for this provisional decision? If it's something that I think that perhaps we could also use a regulation, but we would ask the two parties to tell us which services are the essential services that must be maintained, for example, and we could issue a provisional decision. But as I say, we're continuing to think about these issues. Thank you very much. Chair, do I have much time? "45 seconds. You said that it was impossible to appoint someone to deal with the file for the I said that we have issues with regard to staffing and the implementation of the code, and we have received some additional funding, but we at this time we're unable to have the funding for the additional or more rapid decision. Thank you very much, Mr. Boris.
5 minutes.
Great. Thank you, Mr. Chair, and thank you to all the witnesses for being here today. My questions will start with Ms. Brazeau at the Canadian Industrial Relations Board. I had the privilege of serving on the Passenger Transportation Board in British Columbia, which is an independent tribunal. And having that experience, I know that when there would be applications that would come to myself, there were different types of applications. And you actually refer to that as types of applications. Some of them, when I was going to write decisions and assess them, would take a very short amount of time, and some would take a much longer amount of time, many, many months. They were much more complex. And so I'm wondering if you can just go into a bit of detail as to the type of applications and what the timelines are. I know that you have in chart number 2, you have you've listed the type of applications and then the amount of time that they take, but not necessarily how many applications those were. And so can you just give us some some feeling as to that workload now, and then what you could see that the changes are based on the type of applications and how that might affect your ability to plan and go through all the applications. Thanks.
Thank you for the question. I should point out that at chart 2, I only provided 3 types of applications, which I thought were relevant for the discussion, but we have several types of applications. The maintenance of activities, as it shows here, we know we get about between 25 and 30 of those cases per year. Unjust dismissal complaints is our largest type of complaint. Under Part 3 of the Code, they represent about 1/3 or almost, no, I'd say 1/3 of the caseload of this board. And those are normally sent out to external adjudicators. And with the challenge that we had last year, that's a type of application that is now accruing and in which we're experiencing delays that I consider unreasonable given where we are. Other types of applications, certification applications. So when a union comes in to be certified to represent a group of employees, we deal with those on an expedited basis. We get about, that's about 5%, less than 5% of our caseload. And our objective is to deal with those within 50 days, and we meet that about 80% of the time. So those cases that raise a jurisdictional question would take longer. So unfair labor practice complaints, which appears on this chart, is another large piece of our work. They, I would say, represent about 10% to 15% of our work, and you see the delays there, or the processing time for dealing with those, and those involve anything from termination of a union organizer to interference in bargaining or bad faith bargaining complaints that come to us. So I don't know if that provides a good picture of what our workload looks like.
Thank you very much. I think that gives us a better understanding as to your workflow. The other thing that you had mentioned were the number of vice chairs that you have, and you referenced external adjudicators. So I'm wondering if you can maybe go through with us what your structure is, and hypothetically, if you did have some more resources allocated, how quickly could you even ramp up? I know, again, for myself, I had to go for specialized training at the Justice Institute in Vancouver. And so, are there individuals, whether they're vice chairs or external adjudicators, or maybe those are the same people, I'm not sure. Can you just explain for us sort of how that works, and what the ramp-up time would be to bring more people on board and more resources?
So vice chairs that are appointed on a full-time basis, they're appointed for a term of 5 years with the board. That's a governor and council appointment. And they come, they're identified through a process, an advertisement that is put up by the Privy Council's office. And they, we look for background in labor relations, expertise, and experience with litigation or adjudication in an administrative tribunal. And so they usually come with a lot of experience, but they need to become familiar with the types of files we deal with, build confidence in adjudication, and so over time they become more confident and familiar with the types of cases. And maintenance of activities, replacement worker issues are very particular and require, specialized approach. External adjudicators are
Brazeau.
private arbitrators.
Okay, could you wrap up?
Oh, sorry.
No,
Private
conclude your
are
comment.
private arbitrators that have their own practice, and I have a list of about 15 external adjudicators that I call upon to take on some cases as need be.
Thank you, Ms.
Thank
Gray. Ms. Brazeau. Mr. Coteau for 5
Yeah,
minutes.
thank you very much, Mr. Chair, and thank you to our witnesses today. Appreciate your time. Maybe to Mr. Giz, a quick question. You mentioned that the bill would lead to, by not having replacement workers, you can compromise critical services, but it's my understanding that in the MOAs between organized labor and employers that usually, and it's been in most cases, that those types of services are included in the agreements, and unions usually agree to those types of ensuring critical services are maintained. Is that your impression?
Well, first of all, just let me say that what we're looking for in our amendment is that not for replacement workers, we're looking for our existing employees to be able to work on that continuation of service. But I'll ask my colleague, Mr. Smith, to perhaps give you a little bit of a background legally in terms of how that really works.
Yeah, obviously we don't have insight into every MOA agreement, but it's illustrative that, there's an important case where the board decided in 2003, it's the Alliant Telecom case, that Section 87.4, which deals with maintenance of activities, is not broad enough for them to require that there be a maintenance of the service agreement to cover services necessary to restore outages, what have you. There's not sufficient nexus. So in their conclusion, they said that, that there is not, they do not support a finding that a strike or lockout could result in immediate and serious danger to the health or safety of public if there's a telecom outage. So there's no requirement to enter into a maintenance of service agreement. Now, after that decision was made, there was a subsequent case between TELUS and its union where there had been a maintenance of services or activities agreement prior to that Atlantic Telecom decision. And the board said that the union expressed frustration at having entered into that agreement to provide services. And after the board had concluded that the possible interruption of telecommunications services does not constitute an immediate serious danger to the safety and health of the public, the board further explained that the union considers that the signing of the agreement weakened its bargaining position and caused it to be criticized by its membership. So I don't think you can conclude that there will always be maintenance of activities agreement, and that's all we're asking for. We're just saying if everyone agrees that it's vitally important for Canada, that if there's an outage, that if you're taking away replacement workers, there has to be a mechanism that allows telecommunications and broadcasting providers to restore services, in hours, if not minutes.
Thank you.
Yeah.
Appreciate it. We also heard from one of the witnesses, I think last week, Charles Smith, who's a professor out in Saskatchewan. He actually had a very compelling argument that, traditionally in today's society, employers have always had a bit of advantage over employees. And he talked about how industry groups in general have shied away from bills like this and made the argument that a bill like this could prolong strikes. But he presented actually some evidence in regards to Quebec and BC having this type of legislation in place, and he actually made the argument, and he presented it to us, that there would be actually less strikes when legislation like C-58 was put in place. Maybe to Mr. Carey, has your industry group done any research to support the claim that a bill like C-58 could potentially cause more disruption versus the claim that Mr. Smith has made, that it actually reduces disruption by creating industrial peace, as he referred to it, and creating a better balance between employers and employees?
We've not to that degree. I can say that the agriculture sector does have provisions, like the longshoremen are prohibited from striking, because over the years it was used as a leverage, and then Minister McCauley in Labour in 1998 amended that. So again, I think the agriculture sector's view is similar to the telecom, which is not about replacement workers. It's about allowing current staff within, say, the railways to continue to keep the lights on, because I think our views on Bill C-58 is that you do need to take a sector-by-sector approach when allocating sort of blanket bills. So, we don't have a position on collective bargaining. We respect unions' abilities to do things. However, we are seeing Canada's reputation challenged globally currently with the current legislative framework that we have about our ability to get agriculture products to market. Agriculture is 1 in 9 jobs and 7% of GDP, $99 billion in exports last year alone. And I guess our concern is that this creates more instability with Bill C-58. But again, our comments would be within the agriculture sector and also within, say, railways, grain companies, ports, ability to use current staff, whether they're management or non-unionized, to keep the lights on. We're not asking. Replacement workers can't jump on a rail car and run the thing. They just can't, and that's where major labor instability is. But we are concerned about the trend of labor instability in our grain supply chains.
Thank you very much. Thank you.
Thank you, Mr. Coteau and Mr. Carey. Madame Chabot, pour 2 minutes et demie.
Merci, Monsieur le Président.
Thank you very much, Chair. I think this is our last meeting with witnesses on this bill, and I think this is a rather historic bill that could meet the objectives of prevent the use of replacement workers, and we have to be able to ensure that this bill is dealt with, and there will be a delay before it gets royal assent, and then I think we can't have too many delays, and we can't just say, well, the bill has been passed and we can wait a long time for actually applying it. And I think a serious government would provide all the resources needed to make this bill, once adopted, effective. And I think it's something, preventing the use of replacement workers is something that is very important and will be a significant improvement with regard to the work of the board and to shorten delays. And I think these delays and the lack of resources for the board, it's unacceptable. And of course, if there are strikes, that creates that disturbs the normal situation, and replying with replacement workers, this is a lack of respect for the existing workers, and I think we have a situation where we are lacking respect for workers. Mr. Giz, we're very aware of the importance of telecommunications, like other essential services. But does that mean that we can say that we have to limit workers' right to strike and use replacement workers?
The amendment that we're proposing is not about bringing in replacement workers. As we heard from Mr. Carey, and you just can't take someone and put them running a train. You just can't take somebody off the street and have them working to repair telecommunication services. So it's about making sure that we have the ability for employees in the telecom industry that if there is a natural disaster or something happens where networks go down and people need, for healthcare, for education, for work, for 911. If people need access to these essential services, we need to have the opportunity to keep them up and running. So it's not while yes, we said that we're against the bill, if the bill is going to go ahead, like we're hearing from all parties, then we think that it's vitally important that we have amendments in place to ensure the continuity of telecommunication systems in the event of a outage.
Merci, Madame Chabot.
Thank you, Ms. Chabot. Mr. Boulris, for 2.5 minutes to bring us to an end of this panel. Thank you very much, Chair. Ending, I think that I must say we're very proud of this study, and I think as a member of the NPD, in the context of a minority government, we've been working to prevent the use of replacement workers for a long time, and we want to defend the unionized community in areas that are under federal jurisdiction. We know that everyone has a role to play. I think there's an economic pressure that sometimes lead to use of replacement workers, unfortunately. But in the current situation, an employer that so that employers can continue their activities in the same way, talking about the same jobs, the same hours of work, and if there are complaints, if there are no changes or no amendments to the provisions relating to replacement workers, if there is a complaint from a union that suspects that the employer has changed its activities or the work situation, what would be your reaction if there is a complaint? As I said, under Article 16 of the Code, the board has a very broad powers to investigate, and we would look at the situation and decide whether we can undertake any inquiry and to deal with any changes in the work, the rules of work, or the situation for the workers, and or would there be a need to use the traditional type of appeal to the board and in industrial relations? And so we have a process for investigation, and we would take a decision based on the situation. Thank you very much, Mr. Boulris.
We'll conclude the first hour of the committee's meeting this morning, and also conclude the witness testimony on Bill C-58. We'll suspend for a few moments and then go in camera for the business portion of this meeting. Thank you, Mr. Carey, Madame Brazeau, Mr. Giz, and Mr. Smith for appearing this morning on this important piece of legislation. So we'll suspend for 2 minutes.
you.